I'd like to welcome all of you to the 2010 Dewey Lecture in Law and Philosophy. It's a great honor for us to welcome today our distinguished guest, Michael Walzer from the Institute for Advanced Studies, to our law school. Welcome, Michael. My colleague, Martha Nussbaum, herself a former Dewey lecturer, will introduce Michael in a moment. I would like to take a moment, though, before we begin the lecture, and before I invite Martha up here, to talk about the lecture and why it means so much to our school. The Dewey Lecture was created almost 30 years ago in honor of the extraordinary life and career of John Dewey. Dewey was chair of the university's philosophy department from 1894 to 1904 and founded the lab school in 1896. His work in education theory, experimentalism, and instrumental logic made Dewey a giant. Now, among the esteemed philosophers who have given the Dewey lectures, there are quite an array of names. John Rawls, Nobel Prize winner Amartya Sen, Ronald Dworkin, Amy Gutman, Richard Rorty, and our own Martha Nussbaum. Now, wrestling with questions about the nature of law, the intersection of and difference between law and morality, and the normative and prescriptive understandings of our freedoms, obligations, and restrictions under law all go to the very core of a legal education. But the study of jurisprudence and philosophy mean even more to our school than most schools. My predecessor, Saul Levmore, gave me a gift about 2 months ago, a little gray book that talked a little bit about the history of our law school. And in that book, you could see the founding history of our law school being one which turned out to be a fairly stark contest between the Langdellian view that a legal education should consist of one based upon the teaching of, quote-unquote, pure law, and a view identified with Ernst Freund that the law school should include a strong grounding in jurisprudence. Ultimately, I'm happy to say that the Freund view triumphed, with the first dean returning to his perch in Cambridge. Now, it's particularly appropriate today that the person who is introducing Michael Walzer is Martha Nussbaum, the Ernst Freund Chair in Law and Ethics. Martha is among the intellectual giants in law and philosophy. She is the author of at least 15 books and has edited at least 13 other books. Her most recent book is the recently published From Disgust to Humanity. Martha is not only an inspiration to our students, but also an inspiration to our faculty and to our alumni. And I would like to invite Martha up here to introduce Michael Walzer.
Well, it's such a great pleasure to welcome Michael Walzer. The Dewey Lecture has welcomed, as you just heard, many distinguished political theorists, but there's none whom John Dewey, I think, would have been more delighted to see on this list. Michael Walzer's not only a very distinguished political theorist, he's also, like John Dewey, a public intellectual in the best sense, bringing clarity, insight, good arguments, a passion for justice, and good writing to the American political realm, which is badly in need of all those qualities. And anyway, one is always delighted to see Michael because he's also just a really wonderful person. Walzer began his career at Princeton, but very quickly in 1980 he moved to Harvard, where he taught from, very quickly he moved to Harvard, where he taught from 1966 to 1980. He was one of the luminaries in the government department. I remember when I was a graduate student, he was a legend already, both as a scholar and as a teacher. But in 1980, he accepted a position at the Institute of Advanced Study in Princeton, a permanent position, where he has recently become an emeritus professor. And Walzer has published an astonishing 27 books, so I'm never going to get close to that. So even to list them would take his time away, and of course not to mention hundreds of articles. But just to mention a couple of high points. Just and Unjust Wars, 1977, but many editions since then, is a real modern classic, the best modern exposition of the tradition in thinking about international relations that goes back at least to Cicero, and in fact I've just been teaching your book in my Cicero class, but it's certainly got exemplars like Grotius and Kant in it, namely the tradition that moral norms are crucial and valuable in the international realm, including the realm of war. And Walzer's been a leading articulator of the distinction between just and unjust wars, and over the years he hasn't hesitated to use those insights to talk about particular conflicts. Spheres of Justice is perhaps his most ambitious theoretical contribution. It's known typically as a communitarian work, but I think that label suggests a kind of tepid conservatism, and it doesn't at all do justice to the subtlety of Walzer's argument, which combines a defense of certain universal values such as life and liberty with attention to the many different spheres of life in which norms of justice are worked out. And this book has also become a classic in American political theory and has, in fact, inspired people all over the world. For example, recently we had a joint project on affirmative action with a university in India, and I've been editing the book from that, and I just discovered that one of the best papers in the volume was, in fact, one that used Walzer's ideas to address the whole issue of how a nation like India that's pursuing justice through affirmative action should think about that task. So most recently, Walzer's also turned his attention to the tradition of Jewish political thought, and he's been running a collaborative multi-volume project on that tradition. The third volume is just in progress now, but he's working on that, but he's also doing other current work on toleration and the accommodation of difference. But writing has just been one big part of Walzer's career, and I've actually just been teaching the part of Cicero's On Duties where Cicero lambastes the philosophers who like to hide out and enjoy their contemplative solitude, and they refuse to serve the public realm. Well, that could hardly be said of Walzer. For many years, he's been co-editor of Dissent, which is a magazine, and most of you know it, of politics and opinion that was founded in 1956 by the late Irving Howe. And I think Dissent is a marvelous magazine. Its quality, both intellectual and editorial, is consistently impressive, and it has defined what one might call a kind of responsible left liberal position in American political life, but also in international life, that it articulates with subtlety and at the same time encourages vigorous debate. And it doesn't just preach to the converted. One of my most conservative colleagues told me that he reads Dissent from cover to cover every month and just admires its quality so much and thinks that it defines what the reasonable alternatives are. As a contributor, I've been also fortunate myself to have the benefit of Walzer's criticisms, encouragement, and careful editorial judgment, so I know what a close eye he keeps on everything. I've been particularly impressed over the years by Walzer's way of handling the inflamed debates surrounding Israel and Palestine. Of course, Walzer has a definite view, and it's one that I myself find compelling, combining defense of Israel's right to exist and to defend herself with a balanced criticism of certain specific acts of the Israeli government. But equally important is the way that he's figured out what a productive debate on this would look like, and a way of getting people on different sides of this issue into the pages of Dissent, and encouraging those interesting and not cliche-ridden dissenting voices. For example, a young Palestinian philosopher with whom I recently had a debate in Dissent on academic boycotts. Now, at Harvard, Walzer was a legendary teacher. He was known to be the most charismatic and fun person to listen to, and in fact, one famous course he taught was with Robert Nozick on capitalism and socialism, but another was his History of Modern Political Thought, which really has gone down in history as one of the great courses in Harvard history. But, of course, when he went to the Institute, those talents were lost to many generations of undergraduate and graduate students, but they weren't lost to the audiences for his public lectures So we're in for a treat in so many ways. And so I warmly welcome Michael to give this year's Dewey Lecture on trying political leaders.
That could be a little lower. Trying political leaders. I don't mean trying out political leaders in advance to see if we're likely to find their leadership disastrous. That might be a good thing to do if we knew how to do it. In politics, judgment doesn't have to be, and often can't be, after the fact. But it's post facto judgment that I'm interested in today. My subject is the morality and wisdom of putting political leaders on trial after we have endured their leadership and perhaps their crimes. Political trials have a long history, and the judgments we make of their procedures and verdicts are highly contested. So I'm going to try to suggest a comparative politics of political trials. They have a very different character and very different purposes in different national and international settings. And like all trials, their justice and wisdom depend on their character and purpose. I'm going to consider 4 kinds of political trials, all from the modern period. I'm not able to discuss the Greek and Roman precedents. The 4 are: first, revolutionary trials, like those that took place in 1649 and 1793 in London and Paris. Second, the show trials that are part of a political purge, like the Moscow trials of the 1930s, whose injustice John Dewey helped to expose. Third, post-war trials, like those held in Nuremberg in 1945. And fourth, what I will call post-election trials, like those recently proposed for leading members of the Bush administration. I should stress at the beginning that my perspective is that of a political theorist, not a lawyer. The legality of political trials is often dubious, but that's not my central concern. It's possible, I think, for trials to be legally dubious, but morally and politically right and maybe even necessary. And it's also possible for trials to be perfectly legal, but radically imprudent. Let's begin with the trials of Charles I and Louis XVI by the revolutionaries who overthrew them. These are critical moments in early modern political history, our political history, because we are citizens of a republic. We are the heirs of these trials. Kings had been killed before. Indeed, untimely death was a regular feature of kingship all through its history, but they had been killed by single assassins, like Henry IV of France, stabbed to death by Francois Ravaillac, or murdered in corners, out of sight, like Richard II in Pontefract Castle. When Oliver Cromwell said of Charles that we will cut off his head with the crown on it, he was aiming not simply at the death of a king, but at the death of monarchy itself. And that required, he thought, a public accounting, an indictment and a trial that challenged the legal inviolability of kings and treated this king as a public official answerable to the public, as capable of committing a crime as any other subject of the realm. Not all the revolutionaries wanted to put the king on trial. The debate in France over what to do with Louis raised issues that reappeared in the run-up to the Nuremberg trials and are worth considering in some detail. The Jacobins opposed a trial, arguing that Louis had committed no crimes to which the law reached. His only crime, this is what Saint-Just said, his only crime was to have been king. And this was obviously not a crime under the law of the old regime. No one can reign innocently, said Saint-Just. The verb is crucial there. But in fact, Saint-Just wasn't interested in the guilt or innocence of Louis. What he and Robespierre believed was that ruling as a king, reigning, was an act of war against the people the king ruled. This was an unjust war, a war of aggression. But Louis was not, first of all, a criminal. He was an enemy of the people. An enemy of the people. I believe that this phrase has its origin in the French debates. And since he was dangerous even in captivity, military necessity required that he be killed. He couldn't be treated as a prisoner of war. The legal phrase benevolent quarantine for the duration comes later, but it describes very well what the Jacobins thought impossible in the case of kings, and what the Bolsheviks still thought impossible in 1917 when they acted on the Jacobin doctrine, though with their own special ruthlessness, killing the Tsar and all his family. No Jacobin suggested anything quite like that in 93. Like Cromwell, Robespierre and Saint-Just wanted to kill the king with his crown on, but they were not interested in a public indictment. They thought that a trial was something owed only to citizens, and soon enough they would be putting a lot of citizens on trial. But they saw no need to make a case to persuade men and women who had been ruled by kings for centuries that this king had betrayed them. It was self-evident that kings and patriots were in a state of war. The underlying assumption of the Jacobin argument was that Louis was not a Frenchman. That is, not a member of the nation or a citizen of the state, or most importantly, a party to the social contract. Kings and aristocrats, too, belonged to an international class of parasites and predators who took no responsibility for the well-being of the people they ruled because they were not of the people. And so they had no claim on the protection of the revolutionary state that the people had created. Once a king of France had arrogantly proclaimed that he was the state, l'état c'est moi. Now the Jacobins proclaimed that the king was stateless. I'm not sure that this description, despite its fierceness, was entirely inaccurate. Louis himself might have agreed that he never signed on to the social contract. Nonetheless, it was a dangerous description, since it could easily be extended to other enemies of the people. I much prefer the Girondins, who were the chief advocates of a trial for Louis and who carried the day, though they didn't get exactly the trial that they wanted. They argued that Louis was indeed and obviously a Frenchman. He was Louis Capet, a public servant who had committed the crime of treason. He had conspired with and actively assisted enemy armies attacking the Republic. And of course, the law reached to this crime. Even under the old regime, treason was a criminal act, though it was thought then, mistakenly, that the king could not be a traitor, since treason was defined as a crime against the king. But the king had always been, in fact, an officer of the people, and treason was always a betrayal of the people and not merely of its chief officer. The real innovation of the revolutionaries was to deny the king's inviolability. If the law's reach extended to the crime, then, they insisted, it extended to the criminal. All Frenchmen were equal before the law. This was an invented equality, an ex post facto equality, but the Gironde was willing to live with that, since equality, its members thought, was natural and eternal, even if it was new to French law. It followed from the Girondin argument that Louis should be accorded all the rights of a French citizen accused of a crime. He should be represented by an attorney. He and his attorney should know the charges against him, see the documentary evidence collected by the prosecution, and be allowed to question hostile witnesses and to call friendly witnesses to the stand. What justice truly demands, argued Condorcet, the leading philosophe of the Gironde, What justice truly demands is that the general principles of jurisprudence in favor of the accused should be preserved or even extended. That sort of thing, Robespierre responded, was a sign of delicacy. The term was disdainful. Delicacy in the case of kings demonstrated nothing more than a lack of revolutionary energy. Robespierre and his friends called Louis the last king. Their politics was resolutely forward-looking. Condorcet and his friends called Louis the former king. Their politics aimed at a just reckoning with the past. But the trial that the Girondins wanted was also intended to have consequences for the future. In a sense, it was a show trial, indeed, a splendid spectacle. The king judged by his subjects, his peers. Louis Capet, the former king, standing before the court, exposed as a mere man, all the mythic masks of kingship torn off, but charged with crimes he had committed when he wore the crown. This could not help but be, Condorcet believed, a great moment in the education of the human race. But if it was to make this kind of showing, it had to be a real trial. Its educational value depended on its procedural integrity. In a book that I wrote in 1974, defending the trial and execution of Louis XVI, I adopted what was pretty much the Girondin position. Revolutionary justice is defensible whenever it points the way to everyday justice. That's the maxim that marks off morally legitimate trials from proscriptions and terror. The legitimacy of the king's trial lies first in its resemblance to an ordinary judicial proceeding. Condorcet was entirely right to argue that the nearer the resemblance, the better the trial, the more just for the king, and the more effective for the revolutionaries. But justice in revolution cannot be measured in a purely formal way, for what is usually at stake is not the validity of this or that procedure. There was no disagreement in the Revolutionary Assembly about what constituted a fair trial, but rather what was at stake was the status of the men and women involved. In the case of the king, what was at issue was whether he was justiciable at all. And here the whole purpose of the revolution was to change the law, not merely to apply it. And it's obvious that the proposed changes have to be defended in political and moral, not in legal terms. Hence, the second and more important defense of Louis's trial is simply the claim that to turn kings into citizens is to advance the cause of justice. The trials that accompany political purges are also show trials, but their educational value depends, in contrast to revolutionary trials, on their lack of procedural integrity. The aim is to inspire fear among all opponents and all potential opponents of the regime, and so it is necessary that everyone watching the trial understand that what Condorcet called the general principles of jurisprudence in favor of the accused have no place here. The law offers no protection. If you are accused, you're dead. But then why go to the trouble of organizing a trial? The purge metaphor doesn't suggest the need for any kind of judicial procedure. Corrupt elements are simply removed from the body politic. Indeed, many enemies of the regime in the Soviet Union in the 1930s, for example, were simply arrested and shot. And something like that has probably happened on a much smaller scale in Iran today. Disappearances of this lethal sort certainly have an educational effect. But the organizers of a purge want something more than this, which they apparently think only a trial can provide. Considerable care went into the preparation of the Moscow trials, and we have seen something of the same care recently in Tehran. where it is similarly difficult to understand. What point can there be in organizing a trial if the procedures that constitute a trial are ignored? Fear can obviously be produced in other ways. I think that it's the confession that is crucial in the Purge Trials. Procedural justice is rendered unnecessary by the abject confession of the accused. These two have different purposes. Procedural justice, in the case of kings, for example, was meant to convince the political public that kings were as liable to prosecution as any other citizens. They were public officials who had, in fact, committed crimes. Confession is meant to degrade and disgrace former revolutionary leaders suspected of oppositional tendencies. The charges and then the confessions are unbelievable, contradictory, absurd, and precisely for that reason, the recitation by the defendant of his crimes is an act of self-abasement and political self-destruction. He isn't guilty so much as helpless, beaten, cowardly, irrelevant. The sabotage, espionage, and treason to which he confesses are inventions of the regime which require a radical rewriting of history. And the message that the trial delivers is that the regime can transform the past in any way it likes and is therefore in firm control of the future. It can do anything. Its opponents can do nothing but acquiesce. The trial provides an occasion for their ritual acquiescence to their own political oblivion. But that can't be the whole story. For Stalin insisted that confessions be extorted by torture, if necessary, from tens of thousands of his victims who were never brought to trial, who were simply shot or transported to the camps without any public appearance. Their confessions were sent to the archives, marked to be kept forever. Robert Tucker, the biographer of Stalin, offers a psychological explanation of Stalin's insistence on confessions. Insecure in his paranoia, he needed this confirmation that the people he was purging were indeed enemies of the revolution. But that's especially odd, since he certainly knew that the hostile acts described in the confessions had never taken place. Everyone else should have known that, too. And yet the unbelievable charges and confessions in the Moscow trials were believed by many people, not only faithful communists prepared to believe anything, and not only clever philosophers like Maurice Merleau-Ponty, who argued dialectically that even if the charges were factually false, they were politically true. Independent observers, journalists from many countries, liberal and conservative intellectuals, diplomats like the American ambassador, Joseph Davies, watched or read about the trials and concluded that the defendants must be guilty of something, as if political defeat was itself a sign of guilt. Hence, it was really important to insist, as the members of the Dewey Commission did, that the Purge trials were not trials at all, for nothing was being tried, every outcome was known in advance, and all the evidence was made up. The failure of so many politicians and activists, especially, but not only on the left, to join in this insistence is a lasting shame. Of course, Purge trials do bear some resemblance to real trials, else they wouldn't work at all. Confession is a common way of giving up procedural rights in exchange for other benefits, sometimes life itself. But the resemblances are superficial, and it is still very hard to accept the fact that so many intelligent people were fooled by the Moscow trials. The absurdity of the charges, the groveling confessions, the broken men in the dock. This was terrorism in the guise of justice. Justice after a war is commonly called victor's justice. It resembles the justice done or attempted by triumphant revolutionaries, And after World War II, it prompted similar debates, though with one important difference. Many of those who opposed the establishment of the Nuremberg tribunals did so out of a strong commitment to procedural justice. Their arguments were different from those of the Jacobins, though their conclusion was similar. The leading Nazis should be shot as soon as they were captured. A fair trial, in accordance with British and American principles, was more than they deserved, but even more importantly, much more importantly, it was unlikely that any trial would be fair or would be seen to be fair. The British War Cabinet worried that since, quote, the result would be a foregone conclusion, these proceedings would tend to bring judicial procedure into contempt. As Gary Bass writes in his study of war crimes tribunals, which is my chief source here, the British, quote, showed an unwillingness to compromise the integrity of their traditional judicial procedures and a willingness to be blunt about their unwillingness. The bluntness is evident in Churchill's proposal that the Allies produce a list of the 50 or 100 leading Nazis, and then, this is what Churchill wrote, when any of these persons fall into the hands of any of the armed forces of the United Nations, the nearest officer of the rank of Major General will forthwith convene a court of inquiry, not for the purpose of determining the guilt or innocence of the accused, but merely to establish the fact of identification. Once identified, the said officer will have the outlaw shot to death within 6 hours and without any reference to higher authority. I should add that Churchill responded with high indignation to Stalin's proposal at the Tehran Conference in 1943 that at least 50,000 Germans should be proscribed and shot. The British Parliament and public, he told Stalin, will never tolerate mass executions. Churchill aimed to kill no more than 100, and there would then be trials for all the subordinate war criminals, preferably in the country in which their crimes had been committed. Presumably, despite the designation of these people as criminals, the outcome of their trials was not a foregone conclusion. Churchill's term, outlaw, plays something of the same part as Robespierre's enemy of the people. Both terms describe people who are somehow beyond the law. With regard to the Nazis, Anthony Eden wrote, "The guilt of such individuals is so black that they fall outside the scope of any judicial process. Their fate," Sir John Simon, the Lord Chancellor, told the Cabinet, "their fate is a political, not a judicial question." That was also the Jacobin view of the King's fate, though they expressed it in quasi-military terms and without, obviously, the delicacy of the Cabinet's legalism. In the United States, Henry Morgenthau represented the Jacobin position, and Henry Stimson, with support from Felix Frankfurter, was the Girondin, working out the position that Robert Jackson defended at the London conference and then expressed with great eloquence in his opening statement for the prosecution at Nuremberg. You all know this line, that four great nations flushed with victory and stung with injury stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law is one of the most significant tributes that power has ever paid to reason. The reason for the tribute was twofold. First, the Americans had a strong commitment, often called legalistic, though it seems to me deeper than that word suggests, a strong commitment to the value and integrity of judicial procedures, and in contrast to the British jurists, they were optimistic about the possibility of sustaining procedural integrity in a post-war court. They believed, as Otto Kirchheimer has written, that Victor's justice did not, I'm quoting now, did not exclude judicial freedom of appreciation of the role of individual German leaders. And indeed, that freedom of appreciation led to acquittals as well as to verdicts of guilty at Nuremberg. The Nuremberg results were mostly not, or not entirely, a foregone conclusion. And second, the Americans believed, much like Condorcet, in justice as moral education. Only a trial, only the detailed testimonies and the massive documentation of a trial, Simpson believed, would demonstrate the abhorrence which the world has for the Nazi system of terror and bring home to the German people our determination to extirpate it and all its fruits forever. Now, I'm not going to argue that Nuremberg was a successful demonstration, just as I didn't argue that the trial of Louis was an effective as well as a great moment in the education of humankind. I do believe it was a great moment. Certainly, the impact of Nuremberg was resisted in Germany in the years after 45, and in some quarters ever since then. Though I believe that the trials of Nazi war criminals have had significant, if hard to measure, effects legally, politically, and morally. And curiously, perhaps, or perhaps not, they've had the greatest effect where they were legally most dubious. This is the argument that Judith Shklar made when she discussed the Nuremberg trials in her 1964 book, Legalism. Crimes against humanity was the most innovative of the charges brought at Nuremberg. Kirchheimer called the legal formula problematic, and if you read the lawyer's arguments in 45, it was certainly that, or thought to be that. But Shklar predicted correctly that this was the charge that would resonate over the years. By contrast, in the years since 1945, no one has been brought to trial for the crime of aggression. I don't think trials have ever been suggested for the crime of aggression, which was established in international law well before the Nuremberg trials. It is astonishing to remember that there were lawyers and jurists in Britain and the United States who thought that the Nazi leaders could be tried only for crimes against humanity committed in the occupied countries. They argued, Bass reports, that the killing and persecution of German Jews was protected by German sovereignty. Not protected in the sense that they were permitted or justified by sovereignty, but in the sense that they did not fall within the jurisdiction of an international court. But this claim was rejected by the prosecution and then by the Nuremberg judges. Sovereignty does not extend to mass murder. Today it is widely, though not universally, accepted that a government engaged in the massacre of its own citizens can be overthrown by foreign military forces, and that its officials can then be brought to trial in either a national or an international court. Nuremberg provides the crucial precedent, pointing the way, like Louis' trial, to everyday justice, though the examples of Rwanda and Darfur suggest that we are not there yet. Now imagine the following case. A group of political leaders who have been in power for almost a decade lose a democratic election. Many supporters of the winning party believe that the policies of the defeated leaders were criminal. They involved the violation of specific laws, domestic and international. These victors want to put the defeated leaders on trial, and that, they claim, is a perfectly reasonable and entirely legal thing to do. It isn't revolutionary justice, since the turnabouts in democratic elections are not revolutionary. The regime is not being changed, only the government. The Constitution, the whole legal system, is intact after the election as it was before. No new understandings of agency, responsibility, inviolability are required to justify the trials that are now proposed. Nor would this be victors' justice, as in, say, the Nuremberg trials. First of all, because competitive elections are not like wars, even when we use the language of war to talk about them. We run campaigns. We try to outflank our opponents on the right or the left. We design strategies and tactics. We maneuver for advantage, but we are not, in fact, fighting. And second, post-election trials wouldn't be victor's justice because the trials would be conducted by independent judges who are not newly installed and who are not part of or not participants in the winning political party. The decision to bring charges or to launch an investigation that might result in charges being brought would have to be taken in the United States by the Attorney General, who is a political appointee and whose appointment is politically very sensitive. Nonetheless, the trial itself could be and would be, so its advocates claim, insulated from partisan politics. Nor, finally, would the proposed trials be anything like a purge. The charges would not be absurd, and the defeated leaders would not be tortured. Their families would not be threatened. They would not be forced to confess. Indeed, it is most unlikely that they would even think about confessing. If revolutionary trials and post-war trials can be distinguished from purges, and if they are justified morally and politically, as I have tried to suggest they can be, then surely all the more so can post-election trials be justified. In fact, however, this a fortiori argument doesn't work, or it works the other way. It is easier to justify the trials of political leaders after the major break of a triumphant revolution or a victorious war than it is after the minor break of a democratic election. Trying kings for treason or prime ministers and war ministers for aggression or for crimes against humanity may involve understandings of treason, aggression, and humanity different from those that once prevailed, but these understandings have been vindicated by revolution and war. The trials enact, or this is the claim of their protagonists, the trials enact a new consensus about domestic or international justice. But there is no new consensus after a democratic election. Instead, the defeated party, in opposition now, defends what it did in government, insists on the rightness of its own ideology, and plans for the time when it can return to power and do the same things again. Democracy depends on the willingness of political leaders to go into opposition and on their expectation that they will, or at least that they might, one day return to power. We call this rotation in office, and though it doesn't occur on a regular schedule, it does regularly occur. By contrast, kings and Republican politicians do not alternate in office. First Louis XVI, then Robespierre, and then Louis again. Actually, the Restoration and the revolutions of 1830 and 1848 did produce a rotation, something like that, but not as a settled constitutional arrangement. Nor did we want, after World War II, to see a Nazi regime ever again in power. First Hitler, then Adenauer, then Hitler again. Endings like those of 1793 and 1945 are meant to be definitive. But endings like those of 2000 or 2008, when one political party and then the other was toppled from power, are not in any sense definitive. The truth about democratic elections is that the stakes are fairly low compared to the stakes in revolutions and wars. I don't mean that critically important policy decisions aren't sometimes determined democratically through party politics and election campaigns, but they are rarely determined in any conclusive way. The argument goes on after the decision has been made, and so do the arguing politicians go on. Sometimes the politicians go on and on and on. Perhaps if the electoral defeat is decisive, the defeated leaders will retire from politics, though usually with the hope of being called back. But their place will be taken by younger leaders with many of the same ideological commitments. The stakes are low in this precise sense. No one expects to be killed or imprisoned after they lose an election. Aristotle speaks of the relations among democratic citizens as friendship. That may seem to us too strong a term, but there does have to be some sense among the citizens that they are engaged in a common project, and some readiness to recognize the good faith of fellow citizens who disagree about how that project ought to be pursued. Of course, we also recognize individual greed and power lust and ideological fanaticism that seem to leave no room for the common project. But with regard to critical policy debates, it is important to assume, it's important to be able to assume, that all the parties have the general welfare in mind. It isn't a disaster if our opponents win this time. They won't do anything absolutely awful, and they won't always win. This is how democracy works. All political victories and all political defeats are partial and temporary. They don't put our common project in radical jeopardy. As the saying goes, you win some and you lose some. So we should think very carefully before we do anything that raises the stakes of democratic politics. And winning an election and putting your opponents on trial would certainly raise the stakes. There is a narrowly prudential argument against doing that, in addition to the broader prudential argument that I've been making. If we raise the stakes for them, they can raise the stakes for us. Paraphrasing Saint-Just, we might say that no one can rule innocently. There will always be reasons for a trial. There will always be political maneuvers or policy decisions that violate the law or that can be made to look as if they violate the law. And once the game gets serious in that way, anyone holding office would have a very strong incentive to do whatever was necessary to win the next election. Winning some and losing some would then look like a fool's politics. It would be very dangerous, I think, to start down that path. The opposing argument, of course, is the argument of the Gironde, the argument for perfect justice. Political leaders are not and should never be inviolable. We are a political community of equal citizens. No one is exempt from the law. This is certainly true with regard to what we might call personal crimes. A president who takes bribes or who commits rape or murder should be impeached or defeated and then put on trial without regard to his or her office. But it may make sense, I think it does make sense, to treat political crimes, or what we take to be political crimes, differently. When Lincoln suspended habeas corpus, when Franklin Roosevelt ordered the internment of Japanese American citizens, when Bush and Cheney authorized the torture of suspected terrorists, they were acting for what they thought was the public good, not for any personal good. And the right way of dealing with actions of that sort, if we believe them to be wrong, is to send the rascals home in the next election and then to repudiate their policies. But we might consider here the British position in 1945, which may be more relevant to post-election than to post-war justice. The fate of democratically elected leaders is indeed, as Sir John Simon said, a political, not a judicial question. It has to be worked out one way or another through the political process. But the people that Churchill called subordinate criminals could conceivably be brought to trial for specific illegal actions without dangerously raising the stakes of democratic politics. I'm not easy with that position. I'm not sure it's my position, since it violates the principle of equality before the law. But the violation is in the service, it might be said, of the rule of law, and it would target only people who were not subject to democratic, that is, electoral repudiation. So perhaps we are not a community of absolutely equal citizens. If I capture and torture somebody, I should be tried and punished. If the president orders that done, not to somebody, but to many bodies, acting, so he says, in the name of national security, his only punishment is political defeat, we should vote against him as soon as we can. But there is a line here that must be carefully drawn, and with which I will conclude my argument, though nothing that I've said is conclusive. If the president's violation of the law or the Constitution aims at the creation of a tyrannical regime, if it is his own political enemies that he is arresting and torturing, and not actual enemies of the Republic, or if he's systematically confusing these two, then we have to find a definitive way to defeat or overthrow him. And as part of that process, or after it, a full-scale trial might well be the best available means, not only of doing justice, but of demonstrating, to paraphrase Henry Stimson, our determination to extirpate tyranny and all its fruits forever. But we've not yet had trials like that, and I don't find the prospect attractive. Thank you.
Thanks. That was wonderful. What we're going to do now, we will go eventually to a reception outside, but now we have time for about half hour of questions used against impeachment and have been made, namely that it ratchets up, on each side there will be a retaliation in the next regime and so on. And so that's been one argument against initiating those proceedings.
Right. The advantage of impeachment is that it doesn't take place after a democratic election. It's not the victors putting the defeated people on trial and perhaps in prison. It goes on within the frame of a single administration, and it is a way of dealing with presidents who I think probably it's most often been either used or suggested, I guess most suggested, in cases of what I call personal crimes. I don't think any president has ever been threatened with impeachment because of an unjust war. Maybe I'm wrong about that. There are a lot of people here who know more about that than I do. But I do think of impeachment as a constitutional remedy that is much less dangerous to the political process than post-election trials.
Thanks. Yeah, Eric.
Could you explain more the Girondin theory? It doesn't make any sense to me. This is the legalistic response. So the legalistic response is the king or the leader did not violate the law under the old regime. If we're going to convict him, there's no way we can do that and comply with procedural legalities at the same time, because the procedural legalities would lead us to an acquittal. So you're going to have to cheat at least a little bit on the procedural legalities. And what they do at Nuremberg and some of these other trials is they just cheat on a few of them. They allow you to confront witnesses and so forth, but they might make up a crime or do something else. And so in the end, what does it mean to say that we want to maintain procedural legalities in this circumstance?
Well, it may not be an adequate legal response, but it does seem to me an adequate political and moral response to say that sometimes to cheat just a little bit isn't a bad thing to do, given the alternative. The alternative in the king's case was the Jacobin position. Now, there's also, the story is a complicated one, because the crimes with which Louis was charged were not crimes committed before 1789. They were crimes committed during the period when the revolutionaries were trying to establish a constitutional monarchy, but not with the full cooperation of the monarch. And the monarch's friends abroad organized an invasion of France. And the king was, as the documents discovered in the secret cabinet revealed, the king was in active communication, encouraging this invasion, while he was also presiding, ostensibly, over this revolutionary, but moderate revolutionary government. So he was charged with treason, and the only part of the old law that was cheated on was that the king was thought to be inviolable. It's a big part, yes, but I think the Girondin position, though, makes to me a lot of sense, because it establishes the rule. It establishes the rule of law for all French citizens, precisely by treating Louis as a citizen, even if that's not what he was.
Bernard.
So I'm somewhat concerned that the position that you're taking, the prudential position that you're taking, is very much kind of informed by or influenced by the murkiness of the issues, some murkiness of the issues involving the questions of definitions of torture and who approved torture, et cetera, under the prior administration. And so the question, and so in other words, it seems to me as if kind of some of the murkiness of those issues then turn into prudential concerns of, well, let's not get into this because it gets too messy, and then it seems too vindictive, or it seems too political or something, which then turns into a political theoretic principle against this in the case of post-electoral trials. And my thought is, that's kind of the political theoretic expression of what would sound to me like a prosecutor's decision not to prosecute, simply because this is a little bit murky, and then what's going to happen, there are going to be these consequences, etc. And so if you just take a more kind of clear hypothetical case of a president, say Barack Obama, who signs an executive order saying that the CIA should engage in torture, right? And you've got the executive order. It's not clear to me why an issue like that shouldn't just be dealt with straight up along, criminal law terms, right? In other words, and so it almost sounds to me as if some of your hesitation here, or the derivation of the theory, ends up being very much influenced by the specific fuzziness of the facts about the last administration. And in contrast, if we had simply an executive order that says, black on white, engage in torture, why shouldn't we engage in a post-election trial in a case like that?
Okay, I don't think I was influenced by the murkiness of the issues. I was assuming that they weren't murky. I was more influenced, I suppose, by friends from, or people who've been at the Institute in Princeton from Latin America, who have told me what happens in countries where somebody wins an election and immediately puts his opponents in prison, on trial and then in prison, and how that strains and destroys the democratic, the possibility of ongoing democracy. You will have to tell me whether a presidential order of the court of the sort you described would be proof of criminal intent if the president said that he was acting in an emergency situation to save the country from terrorist attacks. Then what you're involved with is a political judgment, which I think has to be challenged politically, and not judicially. I think the search for a legal procedure for dealing with these questions is a way of avoiding the political process and perhaps of undermining the political process.
Right.
I want to ask you something in a way that follows up on Art Posner's question and invite you to say a little bit more about what you understand by procedural justice, which was invoked a number of times in important ideal here. And the reason I'm worried about this or unclear about it is because some of your cases seem to involve clear violations of what I would have thought were elements of procedural justice. So let's take the Nuremberg case first, right? The standard objection from the point of view of procedural justice of the rule of law was that this involved the application retroactively of rules to people who weren't bound by the rules at the time, right? So it was retroactive punishment for things that in fact weren't illegal at the time that these people did. So that seems to depart from
well, but crimes against humanity may have been a legal phrase invented for the occasion, but murder was a crime under German law, and mass murder was certainly a crime under German law.
Unfortunately, I think it was the case that most of the people who were engaging in mass murder were acting legally under German law, right? I mean, and I think that the people in Nuremberg recognized this, and this was one of the dilemmas, that we were going to apply retroactively to them standards they weren't, legal standards they weren't actually bound by. And I'm not arguing with the propriety of it. I think the Nuremberg approach was the right approach. What I'm really wondering is what you mean by procedural justice, given that it apparently countenances this rather dramatic departure from a standard rule of law ideal. And the other case I'm worried about is the case about the Bush administration. And I'll assume with you that the crimes are clear. Let's just assume there were clearly criminal acts. Well, again, I would have thought it's one of the core sort of rule of law ideals, as you yourself have said in other portions of your talk, that even government officials are subject to the law. And if their conduct is criminal, I don't see what adding the fact that it's a political crime to it matters from the standpoint of the rule of law. If it's criminal, why aren't they held to account before the law just like anybody else if we really believe in procedural justice?
Yeah, I believe in procedural justice up to a point. Like the like the journalist in the Evil and War novel who was under an imperious editor who told him that he was to go to the capital of South Africa, which was Mombasa, and report from there, and he wasn't prepared to say that Mombasa wasn't the capital of South Africa. It was the capital of South Africa up to a point. I recognize that that these trials of the king and at Nuremberg fall short of procedural justice. Although I really don't accept the idea that the Nazi leaders engaged in mass murder believed that they were acting legally. They did everything they could to hide what they were doing, which does not suggest that they were fully confident about its legality. But in any case, what is the phrase? If it wasn't illegal, it should have been illegal. And so to speak, everybody knows that. Everybody knows it was not a strange and alien doctrine to tell the German people that mass murder was illegal.
So through a sharp distinction between trying political leaders for what you call political crimes versus personal crimes. I was just wondering why there's such a big difference. So, in particular, why do you not think that if you try people for personal crimes, you'll get the same ratcheting effect you talk about? So you put Berlusconi on trial for fraud or something. Why is there less worry that when the right wing gets back into power, you'll get tried?
No, I think it's possibly it possibly is. Although if you have proof of bribe taking, I think maybe it won't have those kinds of effects, as in Illinois with the governor of Illinois. I don't think that's going to provoke retaliation.
Because you have more evidence?
Well, because yes, because the difficulty is that when you're dealing with matters of political judgment, matters in which the country has debated and which we disagree about in deep ways, and matters in which people committed to the democratic regime have made forceful arguments for and against. I don't think you want to outlaw one side in those kinds of debates if you believe that, if you hope for the ongoingness of those kinds of debates.
Tom.
Yeah, I want to ask you about extending your argument to post-conflict societies where a lot of political violence has occurred, not a democratic character. So typically in these societies, when we have trials in international criminal law, we only try the leaders and we let the lower level people off. And this is a standard critique. People in Sierra Leone say, why is Charles Taylor on trial, but my rapist or my torturer is living next door? So it's really sort of undermines the project. Now, in democracies, you want to reverse the presumption. You want to let the leaders off and try lower level people. And I wonder, by what criteria do you think we can make the judgment about the right decision for the post-conflict society? That is, should we ask which approach is going to lead to political reconstruction? How do you think about it?
I would ask those political questions, yes. Which approach is going to lead to the best results? So that if a democratic transition is organized, negotiated with a military regime, and the negotiation produces a commitment to amnesty for the generals. And then the transition takes place, and there is a democratic regime in place. I would think that's a commitment that the international community should respect. I thought that the Spanish judge who wanted to put Pinochet on trial after the Chileans had decided not to was acting wrong. Partly for the further prudential reason that there are going to be other transitions which will require these kinds of agreements, and it's better if they be kept. Now, a lawyer at the University of Wisconsin, where I recently visited, said to me that maybe what you need is you give Pinochet 20 years of amnesty, and then the democratic regime can rethink and reconsider, and as they started to do in Chile, and there may be trials in Chile. There were in Argentina of some officers for specific crimes. I don't know how I feel about that, and I'm impressed by the paradox you describe of. I'm not sure I support the position that it's the subordinate criminals that we can go after. There's one question I'd like to pose to you. We're talking about criminal trials, but there are also civil suits from the victims of, say, torture in Guantanamo, which American courts are not currently allowing, but one can imagine civil suits as a much better way of dealing with these questions.
The issue for you is, would you allow a civil suit against the person who ordered the lower torture?
Yeah, right.
Richard. Richard, no, you.
Do I understand? I'm not sure if I understand your position exactly. It is that if people involved, say there's illegal torture occurred, is it that people who are not elected, who are involved in the chain of command down to the torturers, are subject to criminal prosecution because we don't have to worry about them trying too hard to hang on to power because they're not, and subverting democracy because they're not?
Well, I raised that possibility. I did not endorse it. I wanted to encourage an argument about that.
Okay, well, I guess I'll make an argument, which is just, it's kind of practical, I think, in that to actually prosecute such people if you exempt the people who gave them the orders, because it will just seem so unfair to a jury that the people who told them to do it are immune, but the people who had no real power and they could lose their job if they refused are subject to criminal sanctions.
And yet that's more or less what we did with My Lai, isn't it? And with Abu Ghraib, isn't that? And yes, I do think it seems unfair. I'm just not sure what, how far up the chain should the My Lai prosecution have gone.
Jack.
Suppose Germany had won the Second World War, and shortly thereafter, as happened to Churchill in England, Hitler was voted out of office, and his successor, Eisenhower, decides to initiate criminal prosecution of Hitler for the Holocaust. Now, if I understand your view, Nuremberg was okay, but prosecution by the German people of Hitler would not have been okay.
No, that's not my view.
Okay.
Well, there was no ongoing democracy. There were no debates. The Holocaust was not the subject of a democratic debate in which people took different sides. It was from its first moment a monstrous criminal act.
But torture in the United States in the last several years was not the product of democratic decision making. It was hidden from the American people.
Well, in fact, there was a lot of debate.
Well, only after it was revealed.
Well, but while it was going on, because it was revealed, it wasn't ended when it was revealed.
The prosecution would be for the acts that occurred before it was revealed. While it was kept.
I don't know. That's a lawyer's question.
Legal question?
Yes, yes.
David.
The short form of my question is, would it have been appropriate to prosecute Richard Nixon? But here's just to frame it a little better. Let's assume that the crimes in question were violations of the rights of his political opponents that had the effect of making him more likely to be reelected. But let's assume also he had the good faith belief that what he was doing was necessary for national security, because these people were undermining our efforts to be an ongoing leading. And one other factor in the mix, supposing the prosecution had been brought, as it would have been, by an administration of the same party. So under those circumstances, would you say it's really appropriate?
Well, look, if the enemies list had resulted in arrests, visits by the secret police in the middle of the night, the creation of camps for Nixon's political enemies, then yes, of course, there should have been impeachment, rebellion, civil disobedience, uncivil disobedience, perhaps.
He was essentially impeached. He was,
Yeah,
so
right,
that happened.
right.
I mean, he wouldn't have been prosecuted for those things, but he did.
But had, and then a trial. Yes, I think a trial in those cases, not, even if he was, because he was acting in a way which undermined the possibility of a democratic debate and of future and of the integrity of future elections. But
even on the assumption that he thought what he was doing was necessary to protect the
Yes, yes, I think so. I think so. Now that raises all kinds of other problems. Yes.
And then the torture case gets a little larger. I mean, this, the enormity of the torture case is greater, and finds this thing.
Well, I'm not sure the enormity is greater than what I was describing. It's enormity. So.
Jean.
Michael, I wonder how much difference it makes to your argument that in a constitutional republic such as ours, there are all sorts of judicial and legal means to deal with perceived excesses short of putting political leaders on trial. That is, you've got pushback that can go on even as these excesses are occurring. So your option is not a really stark one of either we do nothing about it and it just runs its course until they're voted out of office, and then we can put them on trial. But you've got other means available to you, short of something as
other
stark.
judicial.
Yes,
you have
yes,
other
exactly.
judicial
Other
means.
structures, other
Yes,
ways to.
I think that is important. From my own perspective, I think it is better if policies like torture are if advocates of policies like torture are defeated politically, then overruled legally. But it is important that those protections are in place. It's important that there has been some pushback from the legal community in the United States against Guantanamo.
Allison.
So my question is about jurisdiction, and I think there's this sort of time-honored habit of the target of the political prosecution, the leader, to sort of cite jurisdiction and say, I'm not subject to this court, right? And it seems kind of scoundrelish or even worse in the modern era. I mean, I think we can give lots of examples, including recent ones, where it just seems like this is kind of a naked attempt to stop the proceeding. But I guess it has a sort of different flavor when you think of Charles I or Mary Stuart or earlier people. Now maybe it's just because we can say in their world there was still some belief in divine right or something like that. But I guess, do you think that that possibility is just kind of gone? And so now the jurisdiction claim is really just something that the leader throws out? Or is there still kind of any content to it? And what goes into that?
Well, I don't quite understand the question. The content to what? What is the claim? That
Is it still meaningful for a political leader in the context of a trial to sort of say, well, this whole proceeding is invalid because this tribunal doesn't have any jurisdiction?
It's like an immunity question.
Right. Yeah.
No, I don't think that would not be a defense. I am making a prudential argument against having a trial. If there were a trial, it would be, as many people have pointed out, it would be perfectly legal to bring a defeated or an impeached president to trial, and he could not offer that defense. I don't see how.
And we should think the same thing is true of someone like Charles I, or I don't know if Louis tried to offer it, but is it sort of, it's available in their world in a way it no longer is, perhaps, to say, well, I'm not subject to this earthly.
Well, it had been available, and now the revolutionaries were saying, this is what we have accomplished. It's no longer available.
So the regime change makes it unavailable.
Mm-hmm.
Yes, Ben.
The principal objection to a post-election trial seems to be on the premise that it will raise the political stake unfavorably and unacceptably. And this is on the assumption, or rather the premise, that these issues have been debated rigorously in a society and is a political decision. But this premise is on the assumption that there is a rigorous freedom of speech and possibly by an independent judiciary who will not censor any unpopular political views or political speech. So in this context, I'm just wondering how big the stake will be raised to be subject the leader to a post-election trial. Because the leader will be facing a judiciary which is independent, which is
what that if you believe that the judicial system is sufficiently independent and sufficiently robust, and that the whole country recognizes its independence and its robustness, then the argument might work. But I think if members of the Bush administration were brought to trial, the whole country would believe this was a political trial, and at least half the people would be on each side, and it would not be perceived as the kind of event that you describe.
Back in the back. No, right. Yeah, well, the first one and then the other.
I'd like to bring you back to impeachment, because one of the remedies for impeachment, besides removal from office, is the bar for election or participation in future office, and the taking away of emoluments, pensions, and stuff like that. Could not the legislative body that handles the impeachment, post-election, use just the second remedy and say, from a political point of view, the political leadership of the previous administration did things that were bad, and we don't believe they should have been done it. The sanction won't be put somebody in jail, but it will be a public hearing. Evidence can be brought in because you wouldn't have privilege, executive privilege type stuff. And the situation is particularly relevant in the FISA Fourth Amendment Article 2 situation, where presidents claim FISA is just a statute, we have Article 2 powers that trumps it, and Congress, who adopted FISA, could say, you violate FISA, we didn't remove you at the time, we could still sanction you.
So this would be a halfway impeachment after.
Full impeachment, but the only remedy is taking away removal. He's already been removed if he's been elected. But the remedy is no more pensions and political disgrace.
Yeah, okay. I have to think about that. It's not something that I imagined as a possibility.
Okay, and this will be the last question.
Thanks. Do you think that the same dangers of political backlash and retaliation, etc., are found in third-party prosecutions by organizations such as the International Criminal Court? And additionally, what circumstances make such prosecutions politically legitimate or prudent?
Yeah. We are at the very beginning of this process of creating an international legal system, and it's very hard to imagine that it can be either effective or legitimate until it is part of a political system, until the judges are put into a set of checks and balances of a constitutional sort. Right now, the ICC chooses its cases, I don't know how. It seems to choose only African cases and only cases of countries that are very weak and under-governed. And it may be helpful in those situations, or it may not be. But this is not part of it's not part of a constitutional system. And the decision-making is likely to seem, does seem to me, arbitrary. Now, sometimes that may work. I think that the trials of having to do with the former Yugoslavia in The Hague, which have been described to me, do seem to be just. And they have been, at least in part, negotiated with the governments, the successive governments in the states of the former Yugoslavia. But it's all fragmentary, and it is subject to abuse, as we can as we can see in the actions of judges here or there who claim international jurisdiction over crimes that they pick out of the whole array of available crimes. And who is doing that, and how, and for what reasons? It seems to hang very heavily, as with Judge Garzon in Spain, on the ideological proclivities of a single judge.
Okay, well, we want to welcome everyone to the reception and thank you, Michael, very, very much.